You spent months taking care of that house like it was your own. You paid rent on time, gave your landlord advance notice that you were moving out, cleaned the place before handing over the keys, even took photos just to be safe. And then, a few days later, comes the message nobody wants to read: "I'm not returning your deposit because the house was dirty." In that moment, a strange feeling takes over. It's a mix of anger and the fear of not knowing exactly what to do next. The first question that comes to mind is usually, can he just do that because he wants to? And right after that comes an even more distressing one. Did I lose that money for good? This isn't an exaggeration or drama. In the United States, the security deposit usually represents several $100s, sometimes more than $1,000, depending on the area and the rent amount. For most families, that money is already earmarked for something else: the deposit on the next place, an overdue bill, an emergency fund. Losing that money overnight weighs on your wallet and weighs on your mind. The problem is that many people, in that moment of shock, make a silent mistake. They accept the landlord's word as if it were a final verdict. They think that if the landlord said the house was dirty, then the matter is closed, there's nothing left to discuss. And this is exactly where most people lose money that in reality they had every right to get back. Because a sentence typed in a text message with no evidence, no details, doesn't carry the weight it seems to. And that's exactly what we're going to break down from here on. The house is dirty. It sounds like a simple, almost obvious statement. But when a landlord uses those words to justify withholding the entire deposit, they're making a vague claim with no legal weight on its own. Saying something is dirty is an opinion, not proof. And that difference changes everything. Here's a concept every tenant needs to understand. There's a clear distinction, recognized in most U.S. states, between normal wear and tear and actual damage to the property. A carpet slightly faded from daily use, light marks from furniture on the floor, a sink showing signs of use over the years. That's considered natural. Nobody lives somewhere for months or years without leaving traces that they lived there. The law understands that, and the landlord should too. Different from that is proven damage. A deep stain on the carpet caused by a spilled liquid that was never cleaned up, a hole in the wall, an appliance broken from misuse. Those cases can, in fact, justify deductions from the deposit. But notice the key word, proven. It's not enough for the landlord to simply say damage exists. They need to demonstrate, with details and evidence, exactly what happened and how much it cost to fix. In most U.S. states, this requirement is written into law. The landlord is required to send a written account called an itemized statement explaining item by item the reason for each amount withheld. A generic phrase like "the house was dirty" doesn't replace that document. And when the landlord fails to provide it within the legal deadline, they already start losing ground in the dispute, even before any deeper discussion happens. Here's the most common mistake, and maybe the most costly one, that tenants make in this moment. Faced with the accusation, a lot of people go into emotional defense mode. They start apologizing, admitting maybe they left something out of place, agreeing with details they don't even know are true. That's human. Nobody wants to come across as the villain of the story. But from a practical standpoint, this weakens the tenant's position before any evidence has even been presented. What you need to remember is this: an accusation is not a verdict. It's the beginning of a conversation that needs to be backed up by facts. And that's exactly what we're going to talk about now: how to handle that conversation. Faced with the landlord's message, most people's instinct is to argue back in the same tone, or worse, accept the accusation and give up. Neither reaction helps. The right approach is to respond calmly, in writing, asking for exactly what the landlord is legally required to provide. The first request is simple: the itemized list of charges. Not a lump sum number, but each item broken out, with the specific cost of each one. If the landlord charged $200 for cleaning, you have the right to know exactly what that amount covers. The second request is for photos taken after you had already moved out. This matters because old photos, taken before you moved out, or undated photos, don't prove anything about the condition of the house on the day you handed over the keys. The third request is receipts, estimates, or proof of payment for the alleged cleaning or repair. If the landlord hired a cleaning company, there should be an invoice. If they hired someone to fix something, there should be a receipt. Without that documentation, the amount charged is just an unsupported estimate. And the fourth point, maybe the most important of all, is to remind the landlord, directly and politely, that the deposit cannot be withheld without proper justification under the applicable state law. You don't need to quote the exact statute number for that sentence to carry weight. Simply mentioning that you know this right already changes the tone of the conversation. This kind of response has an effect that goes beyond the legal side. It changes how the landlord perceives you. A tenant who accepts the accusation in silence is seen as someone who won't push back on anything. A tenant who responds asking for specific evidence is seen as someone who knows their rights and won't let the situation slide without an explanation. That shift in posture on its own already resolves a good portion of these cases before they ever reach any formal process. After requesting documentation from the landlord, it's time to look at the other side of the coin, what you yourself have on hand to back up your version of events. The first and most valuable record is photos and videos taken on the exact day you moved out, ideally right after cleaning and before handing over the keys. Not photos taken carelessly, but images that show every room, the corners, the floors, the appliances. The more complete that record is, the less room there is for any vague claim from the landlord. The second item is a move-out checklist signed or exchanged in writing with the landlord at the time you vacated. Many tenants don't realize this, but asking the landlord themselves to walk through the property with you and get it in writing that everything was in order is one of the strongest pieces of evidence there is. If that joint walkthrough happened, and the landlord agreed on the spot that everything was fine, it becomes very hard for them to claim otherwise later. The third point is the messages exchanged with the landlord throughout the lease. Conversations about maintenance, complaints, verbal agreements, later confirmed by text. This history helps show the pattern of the relationship and often reveals that issues being pointed out now already existed before you even moved in. And the fourth point, often overlooked, is witnesses. Someone who helped with the cleaning, a friend who was there when you handed over the keys, a neighbor who saw the condition of the place that day. This kind of account, even if informal, reinforces your version of events. Here's where a turn happens that many landlords don't expect. When the tenant presents this kind of organized documentation, most landlords back down from their initial position. That's because, in a deposit dispute, whoever can prove the actual condition of the property on the day of move-out usually comes out ahead, regardless of who yells louder or who sends the harsher message first. Not every charge a landlord makes holds up to closer scrutiny. And there are situations that come up so often in this kind of dispute that the pattern is easy to spot from a mile away. The first is light dust, the natural buildup that appears within a few days, even in a recently cleaned house. That's not dirtiness that justifies withholding a deposit. It's simply the natural result of time passing between the cleaning and the landlord's inspection. The second is normal wear marks, like flooring slightly worn in high-traffic areas or door hinges showing signs of years of opening and closing. That falls within what the law already recognizes as natural in any lived-in property. The third is small stains that already existed before you even moved in. Often, without a record of the property's original condition, the landlord tries to pin something on the current tenant that had already been there from the start. The fourth situation, maybe the most common of all, is a generic charge with no itemized amounts. When the landlord simply states, "I withheld $200 for cleaning," without detailing what that cleaning involved, with no invoice, no receipt, that charge lacks exactly the kind of support the law requires in most states. And the fifth is withholding the entire deposit based on minimal cleaning, like vacuuming the carpet or washing the kitchen. Services that cost a small fraction of the total amount typically withheld in these cases. Here's a detail few tenants know, but one that can weigh heavily in their favor. Several U.S. states set strict deadlines for landlords to return the deposit or send the itemized statement, generally between 14 and 30 days after move-out, depending on the state. When that deadline passes without a response or without the detailed document, the landlord already weakens their position considerably, even if there's some legitimate reason behind the charge. A missed deadline, in this kind of dispute, often carries as much weight as any physical evidence. After understanding what counts as real justification and what's just a vague statement, the next step is turning that knowledge into concrete action. And that path, in practice, follows a simple sequence. The first step is to always respond in writing. Phone calls and voice conversations disappear into thin air, but an email or text message stays on record, time-stamped, and can be used later if the dispute escalates. The second step is to keep all the evidence you've gathered so far, photos, move-out checklist, exchanged messages, in one organized place. This avoids the scramble of hunting everything down later, in the middle of an already tenser dispute. The third step is to formally request the return of the deposit, citing the legal deadline that applies to the state where the property is located. Mentioning that specific deadline changes the tone of the conversation because it shows the landlord you're not speaking out of impulse. You're speaking based on the law. And the fourth step, for cases where the landlord simply ignores all of the above, is to consider taking the case to small claims court. This process tends to be simpler, faster, and cheaper than most people imagine, and it was created specifically to resolve this kind of dispute between tenant and landlord without needing a lawyer present throughout the whole process. At the end of the day, the point was never whether there was a little bit of dirt in the house or not. The point is to demand that any withholding of a deposit be specific, proven, and legally justified. Thousands of people lose this money every year, not because the law is against them, but because they don't know exactly what to say the moment that message from the landlord comes in. And now you do. If this video helped you understand your rights better, hit like so more people in your situation can find this information. And subscribe to the channel because every week I bring real cases and explanations like this about landlords, HOAs, banks, and everything involving your rights as a property owner or tenant in the United States.